Hello everyone, I am Desiree Joy Valladolid, your virtual classmate for today. And now I'm going to discuss to you about the intellectual property rights applicable to the educational setting. Know your rights! And for our objectives, by the end of the presentation, learners will be able to, first, to understand the law governing intellectual property. Second one, to know the meaning and types of intellectual property, infringement, and case study. The last one, to conclude the topic. WIPO, or World Intellectual Property Organization, was established by the WIPO Convention in 1967. It promotes the protection of intellectual property throughout the world. Its headquarters are in Geneva, Switzerland. On World Intellectual Property Day, April 26 this year, WIPO's focus is on promoting visionary innovation as the key to a secure future. There are different intellectual property such as patents, copyrights, trade names, trademarks, as well as trade dress. So there are many types of intellectual property. The first one is patent, the second one is copyright, and the third one is trademark. If you will notice the diagram, you will see their differences, and later on we will discuss them one by one. And now let us know what intellectual property is. Intellectual property is a property that arises from the human intellect. It is a product of human creation. Intellectual property comprises two distinct forms. These are literary and artistic works, and the second one is industrial property. Let us know their differences. Literary and artistic works, these are books, paintings, musical compositions, plays, movies, radio or TV programs, performances, and other artistic works. How are they protected? They are protected by copyright. On the other hand, industrial property describes physical matter that is the product of an idea or concept for commercial purposes. These industrial property are protected by the patented objects, trademarks, industrial designs, trade secrets, layout designs, as well as geographical indications. Now let us know the patents of intellectual property. Patent is covered under the act called the Patents Act of 1970. It extends to the whole of India. It shall come into force on such dates as the central government may publish by notification in the official gazette. So what are the requirements for a patent? To obtain a patent, the new invention must be first in novels, not known or used in this country and not published anywhere. The second one, non-obvious. Cannot be an obvious way to do something. And of course, it is useful. It must have some application, even if not commercially practical. Remember, patents describe an invention for which the inventor claims the exclusive right. Remember, patents describe an invention for which the inventor claims the exclusive right. Invention is patentable if it is new, useful, not obvious, and it pertains to patentable subject matter. With regards to the patentable subject matter, invention should relate to a process or product or both. Involves an inventive step be capable of. Industrial application, a machine. The term of the patent is 20 years from the date of filing for all types of invention. Priority date is the first to file. The date of patent is the date of filing the application for patent. The term of the patent is counted from this date. This is the patent look like. And now let's move on to copyright. Copyright is an intangible right given to the author or originator of certain literary or artistic production. Works created after January 1, 1978 are automatically given statutory copyright protection for the real life of the author plus 70 years. Copyrights owned by publishing houses expire 95 years after publication or 125 years from the date of creation, whichever is first. If multiple authors expiration is 70 years after the death of the last surviving author. Facts are not copyrightable. The Berne Convention provides international protection for copyright for citizens of the 96 signatory countries. It exists automatically upon creation of an original work, but placement of copyright symbol gives notice and to. Judicially enforced copyright requires registration with the U.S. Copyright Office. Below are some examples of copyright. First one is writings such as novels, textbooks, etc. Computer software, songwriting, song recordings, my PPT slide, although some parts included fair use copyrighted material from textbook authors. We use the word infringement to prove a violation. The plaintiff must show that the work was original and that either the infringer actually copied the work or the infringer had access to the original and the two works are substantially similar. A court may prohibit further use of the material or the destruction of infringing material, require infringer to pay damages. And one of the intellectual properties is the trade names, which identifies a company, partnership, or business. It cannot be registered under federal law unless they are also used as trademarks or service marks. It needs common law protection. The image that you see is the example of trade name. Another example of intellectual property is trademarks. What is trademarks? So these are symbol, logo, word, sound, colored sign, or other device that is used to identify a business or a product in commerce. So these are the different symbols of trademarks. First, the TM symbol that is intended to use application file for product. The SM symbol is intended to use application file for services. And the R symbol is for registered trademark. Again, trademark is a distinctive mark, motto, device, or implement that a manufacturer stamps or print on its goods. Trademark is valid for 10 years from the date of application, which may be renewed for further period of 10 years on payment of prescribed fees. Service mark rights are reserved exclusively for owners for 17 years, and it can also be renewed. Trademark helps to assist customer in identifying a product without confusion. If a business uses the trademark of another, consumers are misled as to whom made the goods. The following are the types of marks. First is the trademark, affixed to goods. Next is service mark. It identifies services, not goods. The third one is certification marks. These are used by an organization to attest that products meet certain standards. And lastly, collective marks. These are marks that identify members of an organization. So what can be trademarked? Those are words that are used as part of a design or device, or words that are uncommon or fanciful may be trademarked. And what cannot be trademarked? Those are the personal names, descriptive or generic words, or place names. Examples are books, pencil, Carper, and Hawaii. And for our conclusion, create yourself rather than using others' creation. Another is that do not use competitor's mark in such a way that it harms competitor in unfair way. And always remember that no comparisons that are likely to cause confusions. So that's the end of my discussion for today. Thank you for listening. I hope you learned something. Again, I am Desiree Joy Valladolid from Bisad 2 Filipino. Thank you.